let them know that they need to be accountable for their actions. You know, that's what it is, point blank. And don't, you know, the doctors, these good doctors, there's a lot of good doctors here, you know, and for some of these doctors to say what they said about they're going to leave Ireland or they're not going to take Ireland, oh, you know, man, be ashamed, man. You should be ashamed of yourself. What you should be doing is coming up with solutions to helping the patients and stuff like this, you know, or the legislatures come up with a solution on how we're going to afford to go off island to see specialists. That's what needs to be done.
Thank you, Walter.
No problem, Chris. Anytime. Anytime you guys need me to get up there and speak on behalf of anything that has to do with medical, believe me, I'll be more than happy to, because I got a lot of proof.
We're going to bring Speaker Terlaje on real quick before we let you go, Walter. Of course,
okay, no problem.
Speaker Therese Terlaje. Walter Duenas, I know you're in the Zoom room listening to Walter's story.
Yes, half a day, Walter. Thank you for sharing your story.
Yeah,
and I'm very sorry for what has occurred with you. I really feel for you. There are others with stories, unfortunately, like yours. But I do appreciate your willingness to testify tonight at the hearing, and that and encouraging everybody else to come out and testify. I think that is what is really needed.
Yes, of course.
Thank you, Walter.
All right, Chris, no problem.
God bless you, and God bless Robert. That's that.
Okay. Thank you.
Well, Madam Speaker. Okay. Madam Speaker, you know, anecdotally, right, and a lot of times when you hear stories about families who feel like they've been, you know, victims of malpractice, when they find out is when the person, child, relative, or whoever was cared for locally goes off island, and then you get the off island doctors. I've heard it, gosh, so many times. What did they do? Who did this surgery? And that's kind of what happened in this instance, right? But again, that arbitration cost, I mean, Walter said right there he can't afford it. Tens of thousands of dollars.
That's right. So, and that is really the whole purpose of this bill. It's just because it's been laid on it's been laid bare in front of us as senators and as an entire community that we have a system of justice that is actually preventing a huge portion of our people from seeking that justice. And so we are just trying to correct that with this bill. We're trying to change this mandatory arbitration practice that is actually very costly, very expensive, and requires plaintiffs within 1 year to come up with a significant amount of money, including often $10,000 filing fees and, you know, up to $40,000 to $50,000 when you count in the arbitrator's fees, because it requires 3 arbitrators, 1 physician, 1 doctor, and 1 other person. And so just to cut down on those costs. And so we're trying to find a way, while we continue to recognize the importance of doctors in a community such as ours, our limitations in attracting doctors, we're continuing to recognize those. But I really believe that everybody had come to the table in the, you know, over the last couple of years, with the 3 hearings we had and the meetings that we held, and that everybody agreed that this is an issue we have to fix, and that we can't sit as a community and let only some be able to avail of justice and not the others. So
when you say everyone agreed, and you had all these meetings, were any of them doctors? Because when you watched that press conference, they were just vehemently opposed to this legislation. And I'm wondering, is there any middle ground that can be found, or any sort of a compromise?
Right. Well, no, that's correct. So in the last, well, they're vehemently opposed to this legislation. That's correct. I would say most of the doctors. So that is what we are seeing right now. But unfortunately, a lot of them are advocating status quo. And when I say I thought we had an agreement, it's that I thought it was made very plain, not just for us senators, but for the doctors as well, through all the hearings that we had in the past few years, and that there is something unjust about this system that needs to be fixed. And so that's what I mean. And yes, they, if they're advocating for status quo, I'm looking for a better solution than that. That's not a solution for me. So I'm looking for something else. And so there are options, of course. We could pay, the government of Guam and the taxpayers could pay all the costs for a special process for doctors. For example, a costly arbitration process. That was one of the proposals made by the doctors. I didn't think it was necessary to put an additional burden on taxpayers to do that. I think I've come up with a bill that is reasonable, that it really allows patients and doctors to go to arbitration and to decide what those costs are going to be, as opposed to being mandated to go to arbitration under a very certain procedure and a very costly one. So in allowing arbitration by mutual agreement, this allows them to control the costs. And that's a big, huge thing. And if you're not able to go to court until you go to arbitration, then that's big, right? Then you need to be able to afford arbitration. Otherwise, you're denied from going to court at all. And so we've allowed for arbitration by mutual agreement. And this is what is allowed in every other case on Guam, every other type of injury that has occurred, and it's allowed in many other jurisdictions, that they encourage arbitration, but they don't require you to go to the most expensive type of arbitration. In fact, in a lot of jurisdictions, they mandate that the arbitration is going to be with a minimal cost, and they outline those. But anyways, we've also allowed in this bill for mediation. And so I think that, to encourage continued relations between the parties, mediation is an alternative dispute resolution that some other jurisdictions use. So I also put it in the bill that we would allow that, and not necessarily mandate arbitration, but allow you to choose arbitration or mediation. And if you cannot agree to either of those, then we have put it's like a backup. We put in a magistrate to be the hearing officer when you cannot agree for arbitration. Then it's this magistrate. And of course, I looked across every other jurisdiction to see what is fair in choosing a hearing. It's like a pre-screening panel, right? So in all the other jurisdictions that have pre-screening panels, I tried to see what is fair. And I think, I don't have the numbers right in front of me, but I do have the numbers. And a lot of these jurisdictions are court-appointed type screening panels. And they're, sworn to be impartial and to act as a judge would act. Impartial, without conflict, to examine all the evidence, to hear the expert witnesses on both sides. And so that's what I was trying to come up with. And so that's what I'm
Can you please clarify, Speaker? I was watching a portion of the press conference that the doctors had held on Monday, and I believe it was Dr. Hoa Nguyen who made mention of the fact that the current law was crafted by Dr. Joe Stadler and I believe Dr. Chris Perez. So with your bill, was any input provided by the physicians? Any physicians?
I don't know if you remember, Bree, that we had at least 3 hearings on the mandatory arbitration for Guam's medical malpractice. That we had 3 hearings because of this issue to hear from both sides. We also had meetings, and that's where I'm saying that's how I know what the doctors were proposing, at least a group of them. There's a group of them that are very vocal, and they've met with me, and they've proposed that, we put this, that we charge the doctors $100 each, and then the rest we cover with, government taxpayer funds to fund a pool that's going to pay for arbitration. So yes, of course, I have met with them, and I continue to invite them to meet with me. But no,
Speaker, let me ask you though, would it be
when we introduced the bill, we introduced this bill in November, right? And that was after all those hearings and compilation of everything that we could come up with. Yes. and then we reintroduce it again this next term because it's a new term. Sorry, Chris.
Would it be a conflict necessarily to have the doctors, be involved in the crafting of a legislation that amends a process that attempts to hold them accountable, though?
What we are doing right now, this is the legislative process. We draft a bill, we invite testimony on it, we invite input on it, and then we amend it if we can find anything better that has been proposed to fix that. And conflict, I wouldn't say necessarily, because look, I mean, I had to have 3 arbitration hearings in particular, on this topic only to get enough details in order to craft this legislation. I had to look at many other jurisdictions. And so this is why we are affording the doctors an opportunity to weigh in. This is exactly how the legislative process is supposed to run. So I'm hoping that that's what's going to happen tonight, that they're going to come and they're going to testify and they're going to tell us how to make this bill better. And that they're going to acknowledge, I'm hoping, that there is an issue that needs to be solved, that we are trying to solve, and that if they have any better suggestions, that they're going to put those on the table as well. That, and that, of course, this bill does not solve every healthcare issue. It's never proposed to do that. We work, issues all around. We've had oversight hearings over these licensing boards, GMH, many different things. And I would encourage the doctors to participate, who are not on these boards, to participate more in those hearings as well. Because I think that I've seen several letters that ask that we, take a closer look at these licensing boards, whether they could be the solution to this type of an issue. And licensing boards are different. So right now our licensing boards, they will look at complaints, and they're supposed to be able to, suspend your license, revoke your license, or issue you a reprimand, or, dismiss the complaints. And so we actually haven't had oversights regarding this process because of complaints that the boards were not addressing complaints. So we looked at all the complaints since 2018 till now. And at least for the medical licensing board, we found that there were really no cited violations. All of them, the findings were that there were no violations. So that's the medical licensing board. And so we're continuing to work with these boards, to make sure that they get their money from public health, to make sure that each board is allocated what they're supposed to be getting. They have had proposed to me maybe, I want to say 2 years ago, that they were going to solve all of this by getting a hearings officer from the Attorney General's office, a prosecutor that they were going to hire, an investigator that they would hire. And so I've been following up with that type of thing with our oversight hearings, and they have, issued RFPs. And but to date, there's been no formal hearing like that. So most of the adjudications have just been done by the boards themselves.
Madam Speaker, if you could also address, there's an issue I've seen several doctors bring up about Bill 112, and they say it's going to create a litigious environment, meaning it's going to make it easy for people to file frivolous claims. How do you respond to those points?
I guess I'm not really following the rationale of that, because the bill, first of all, the court system does not allow frivolous claims, right? They have a process to weed out frivolous claims. There's so many barriers before you can even file a claim that even the process itself and the cost of this process normally, I think, naturally weed out frivolous claims. But my bill in particular is it allows arbitration, just like the current arbitration. So if the current arbitration is able to screen for frivolous claims and make a determination for these parties as to whether this claim is a good one or something that they should recover on or not, then that's exactly, this bill is going to do that as well. The only difference is that it's been recognized that poor people cannot avail of the current arbitration system. So the difference in what we have now and what I'm proposing is that more people will be able to avail of either arbitration or mediation or pre-screening magistrate screening of their complaint. And that's how we're going to prevent frivolous claims. The bill also provides confidentiality throughout this process for doctors, because I've heard they're concerned about their reputations being ruined by people just filing claims and saying things about them. And so I agree. I don't want frivolous claims. I don't think Guam is a litigious society. I don't think anything in this bill is going to change Guam, the people of Guam, and how we are going to interact with our doctors. We are not litigious people, and I'm a lawyer, and I know that. And it takes a lot for people to come up and want to sue a doctor or to want to claim anything. And that's because most of the time they do that if they truly believe that it is an egregious situation, that there is true negligence. And we need expert witnesses. You're going to have to find an expert witness to swear that this is negligence. That's very difficult. And, if you can't get an expert witness, which is for doctors, it's another physician. If you can't get another physician to say that malpractice was committed, you're going nowhere. You can't even get into arbitration. You will never. You can't even get, you shouldn't be before the magistrate because you've got nothing. You really need that. And so that's why I don't think they're frivolous, because you've been able to secure an expert witness that says there was negligence in that case.
Madam Speaker, can you hold through? We're just going to jump over to KUAM TV real quick. Thank you. Again, our listeners on the breeze, we're KUAM FM, Agatni Guam, and KUAM TV. Here we come. Good morning, Guam, and good morning, KUAM TV. My name is Chris.
I'm Sabrina.
Jason Salas. Of course, this is The Link, brought to you by Pacific Points, Calvo Enterprises, IT&E, and Jack in the Box. We have your news coming up shortly, but we're going to continue our interview with Speaker Therese Terlaje on the day of the first public hearing for Bill 112-36. Public hearing, 5 p.m., the Guam Congress Hall. Speaker Terlaje.
I wanted to follow up on the press release, because earlier when the bill was introduced, there were, it was announced that there were all these co-sponsors to the bill. Then we saw the Vice Speaker, Tina Munoz Barnes, pulling out her co-sponsorship. What about everybody else? Are they all standing in support of this legislation? Are you aware, Speaker? Because there's quite a few of your colleagues.
Yes, and I want to thank them for that at least, for sticking by the bill and allowing the public hearing process to proceed. And I think that's the only way, in the end, senators are going to make a final determination, and that is through a public hearing process, which is what we are trying to do. And so I want them to hear everything there is to hear regarding these bills. I don't think any of us should, refuse amendment of the bill if that would help, reach its goals. So yeah, so far I haven't heard of anyone else who's going to pull out at this time. And I think that they're waiting to hear the testimony, and so that they can continue to keep, an open mind until they hear everything. And I think the reason we were able to get these sponsors is because we held so many hearings before, and we vetted this issue quite a bit. And I would say more extensively than any other issue has been vetted because of the controversy. We pre-vetted it and then introduced the bill. And so we've had a lot of opportunity to, hear concerns, try to address those concerns, and we will continue to do that. I have utmost faith in my colleagues that is what they are going to do. That is how legislators operate. They hear the testimony, and they try to improve bills.
Well, having said all that, with the public hearings, this has been an issue that's been on the table now for quite some time. What is just your reaction though to all? I don't want to say
you're getting dragged, Speaker. I mean, you got doctors saying you're brainwashed. You got doctors saying that you and Tella don't care about women and children. I mean, did you anticipate this heavy of a backlash for this bill this early on?
No, of course not. I didn't. Like I said, I really, maybe that is, naive of me, but I really believed that having vetted this issue in front of the entire community, that our entire community would agree that we would not stand for only the rich can seek justice if negligence has inflicted an injury or death upon their family. I didn't think that would happen. I really thought, like I had heard in some of the other hearings, that they would recognize, and I do hear this from some of the doctors, they recognize something has to be done. Let's find a way to do it. But what I think happened, I don't know, but they did react with a lot of fear of being sued. And I don't think that this bill necessarily leads to that. This bill gives options for pretrial screening, just like arbitration, mandatory arbitration is a pretrial screening. And it's intended to do the same that the mandatory arbitration was intended to do, but but this bill would make it more affordable. Really, that's the difference. So they still have their pretrial screening. They actually are going to have confidentiality, but it will not exclude, anyone who can't come up with $40,000. It's not going to exclude those people. And so I think that is fair. And I want, as much as we love our doctors, and who doesn't love our doctors? They delivered our babies. We grew up with them, most of them here. I consider them my personal friends. And so I feel very sad that they are reacting, that this is something to attack them when it is not at all intended to do that. And I sincerely believed that they also recognize this injustice that we have before us and that they were willing to solve it. And so some of them have sent me letters with very, concrete solutions for that issue. And recognizing that, we have to continue to work together in this community for everything. We've got to fix our entire healthcare system together. And this is one aspect of it. It's really the justice system that is in need of its fix here. And, we tackle these issues one at a time and day by day and never stop. I have never stopped trying to advocate for the Guam Memorial Hospital, to make sure that it can do hiring as it needs, that it can set salaries for professionals so that we can recruit and retain them, that we can fix the roof over there so that professionals would feel like they are in a professional environment and can absolutely take care of their patients, to try to give them more resources. They come in at the latest budget and ask for nothing, ask for no CIP funds, and it's the same thing, with the medical licensing boards. We are trying to assist them so that they can do their jobs. And I am not going to stop doing that. I have not stopped, caring about and being grateful for what the doctors have done. That has not changed. I am still absolutely grateful. But I would hope that, with gratitude and with understanding of their situation, that they still will not turn their backs, on one class of people. I just don't think that's blatant, that's just a blatant injustice that I don't want to stand for. I am happy for those in our community who agree and who will not stand for that. And I think we can fix that. So I'm asking for a productive dialogue, and let's fix that. And a lot of the things in this bill, Sabrina, when you asked me about the doctor's input, it came from them, you know? But I just didn't go the way that one group wanted, and that was to put it all on the taxpayers. We put some of it on the taxpayers, but at a very reduced amount. A magistrate is going to handle the, pretrial screening. But a magistrate, the way I calculated it with the number of cases that we have had, they could probably handle 7 cases in 5 years, right? On their current dockets. That's what we're predicting. There may be a few more, but we'll see really whether this opens floodgates, because that's what they predict. And everything else that they say, the doctors are saying is based on this opens the floodgates. And I think if you really examine that basic premise, that it's not correct. It does not open floodgates. There is still a huge barrier to get any kind of access to the justice system, to go to trial in any case, let alone medical malpractice. And medical malpractice, even by this bill, continues to set up, a pretrial screening process that's not afforded to others in our community, not afforded to, construction injuries, not afforded to any other corporation, business injuries, nothing. Only that the judge came up with, she recognized that, she said it would be a manifest injustice to require poor people to go to arbitration, and that it would shield these healthcare industry from any type of liability where there has been negligence, in those cases. So she was looking at it to see whether there was a way where she could bypass the arbitration herself, right? Where she could just say, in this case, I'm going to make a ruling that you get to arbitrate. So she sent it over to the Supreme Court of Guam for determination. I don't think that was made. So my understanding, and this is just my understanding, is that since then, the parties have agreed to arbitration because the provider's malpractice insurance company has agreed to pay for all the costs.
While we're on the subject,
so that's why, it's actually a common solution that was proposed at all those other hearings, was just change the type of arbitration we have. Just change that system so it's not the most expensive system. And that's what happened here, is the parties agreed to another type of arbitration where one side was going to cover for the other side, and they I think decided. So that's what I want to do. By allowing arbitration under the Guam arbitration law, it allows the parties to decide how they are going to solve this, or how they're going to go to arbitration. Is it 1 panel member versus 3 panel members, right? Who would they be? So in a lot of arbitration cases, they use retired judges. Just one person, a retired judge. That's, of course, much less expensive than the 3 persons, 1 physician, 1 lawyer, 1 other, and, traveling sometimes from the States, and filing fees that are exorbitant and things like that. So there is, I think, huge room here for physicians to feel, to feel good, because in other jurisdictions, that's how arbitration works. You agree to arbitration at a type of arbitration that you're going to be able to either afford, or, they don't mandate that you go to a certain type of very expensive arbitration.
I wanted to ask if you could respond to the point that was raised by, I don't know if it was one of the doctors. I saw it somewhere where they were saying a magistrate judge is not a doctor, therefore they don't have the expertise to review malpractice claims.
Well, I would agree that a magistrate is not a doctor. Whether they have the expertise to review a malpractice claim, our system of justice right now allows juries to determine malpractice claims. They are not doctors either. It also allows judges to review malpractice claims, and they are not judges either. And they allow arbitrators who are not physicians to review malpractice claims. In fact, our law mandates that one of the arbitrators is a lawyer and one of the arbitrators is a non-lawyer and a non-physician. And but all of these non-physicians will be informed in every case by an expert witness. That's how it works. So in order to say that there was negligence, you need a doctor, a physician, an expert witness to come in and say to the jury, to the judges, to the magistrates, to any other screening panel, to arbitration panels, we need that expert witness to come in and say there was negligence and to explain why. And both parties are allowed to bring in these expert witnesses, and that is exactly how it works. So nobody is there's no the magistrate's not going to be making a decision in a vacuum. He's making a decision based on expert witness testimony. And of course, they're going to have to do their due diligence, just like a jury, just like judges, just like the arbitration panel that's never heard of this case before would have to do. It's the same thing. And the good thing about it is that magistrates are sworn to the Code of Judicial Conduct, just like judges. They're supposed to be impartial. They're supposed to, do their due diligence. And this is their job, is to mete out justice. So they're supposed to be fair. And so that's what I did. I tried to look around the community for who are we going to, if we were going to create a panel, who can we put on it? We've seen that the medical licensing board sometimes has problems finding doctors who will serve as expert witnesses in their licensing procedures or their, complaint investigations, because they don't want to go against anyone else in their own community. We have a small community. And so I didn't want that either. And I didn't want the plaintiffs to think that they were, anyways, if there are other ideas, I'm open to that. But I looked across every jurisdiction to see how they create their panels. And I tried to come up with where on Guam we could fit this in without huge costs, where on Guam we could fit this in that would be fair and would be fair to all sides.
So the hearing is 5 o'clock tonight. How is this going to work? So some people will be testifying via Zoom. Others will be there in person. What I want to
on this hearing, and that's because of my experience in the last hearings. When we go to 10 p.m., I just thought people were getting very impatient and they frustrated, and tempers were flaring. So I want to try to avoid that type of thing. So I said the hearings are from 5 to 8:30, and I've set 2. And if I need to set more, I will do that. But I am going to try to get a mix of the people who've already signed up to testify. We already have quite a bit. And anyone who shows up, of course, can sign up, and we're accommodating those who are not able to be physically present, and we're going to accommodate them by Zoom. So again, so it's tonight, July 7. It's also July 12th. So if you're not able to testify tonight, please sign up for July 12th. And so I'm hoping we're going to get through everyone. I'm not going to cut it at 8:30, but I'm going to, that's my goal, is not to go so late that the senators can't hear anything anymore, right? And that they're still fresh enough to really comprehend and have patience, and that everyone will be able to have patience with each other. So we will continue to accommodate testimony, and we're still accepting written testimony, and you can still call my office anytime you want. But we're going to try to do a mix tonight. Yes, patients really want to be heard. I think they need to be heard as well. I agree with you.
I just wanted to give you one final opportunity to respond, because we have heard, like I mentioned repeatedly, about this press conference, and there's just a lot of emotion with these physicians, and one of the things that they've been saying is the timing of this. We're still fighting COVID, and we're being required to hold the line. We're saving lives here. What is your response to that? Because they feel like you're attacking them.
And is that relative to this bill?
Well, if they, most of these physicians have been here for the past 2 years. and they know that we have been discussing this for 2 years at least, right? And that the complaints that come up before I even became a senator about our mandatory arbitration, that they continue to raise issues. So what I did when I was shown that this is an injustice issue is try to have full out discussions on it. And we did this even prior to COVID. And it's just something that we only have a limited term as a senator, and I want to complete while I am here. And it's something, if I don't do it, I'm not sure if anybody else will tackle this. I have colleagues who are sticking with me, and I'm very grateful. And but it takes huge, willingness to be attacked just to make this shift in our justice system, just to ensure that the poor people can get access as well. And that's all I'm trying to do. I was not trying to attack any doctors. I have no idea why they're calling me a bully, brainwashed. What did you say, Chris?
You don't care about women and children. And tell us.
Oh, that I don't care about women and children. I know. So, I'm going to take that all with a grain of salt. That I agree that they are exhausted. And so, I hope that they can also just try to understand that nothing about this was meant to attack them. It's meant to solve an issue that I thought they all understood, that they all, as part of our community, were going to be willing to help us solve. That they were not going to turn their backs on this entire class of people not being able to seek justice.
Thank you, Madam Speaker.
Thank you, Speaker.
Thank you,
all right.
Thank you, Sabrina.
Good
Take
luck
care, you
tonight.
guys.
Yeah. I mean, God, this press conference, some of these doctors need to go teach drama over at the University of Guam, because the theatrics that are going on with this. They don't like it built out and pack up and do it and go home. And I mean, no one said we're not grateful for this pandemic, but we're all tired from the pandemic. We all went through the same pandemic, and I'm sorry to say, but healthcare was one of the aspects of this island that made a lot of money during this pandemic. So it's not like they were out here doing stuff for free. I mean, you got to get paid for what you do. But the argument that we should throw this bill away because